Thank you. Good morning and welcome to the Missouri Financial Planning Webinar for Older Adults. Today's program is brought to you by the Missouri Department of Health and Senior Services and Legal Services of Eastern Missouri. Before we begin today's program, please accept the following disclaimers. First, today's session will be recorded and may be made available for distribution. Secondly, the information provided in this webinar does not and is not intended to constitute legal advice. All information, content, and materials are made available for general informational purposes only. Additional resources and links to third-party websites are for the convenience of the user. Please consult an attorney to obtain advice with respect to a particular legal matter to ensure that any specific course of action is appropriate to your circumstances. Now let's jump in. My name is Latasha Barnes, and I'm an attorney with Legal Services of Eastern Missouri. At Legal Services, our promise to the community is action, justice, and hope. We act for others, we are a voice for justice, and our actions provide hope. Legal Services provides free legal help to improve lives, promote fairness, and create opportunities for those in need across 21 Missouri counties. At Legal Services, we provide holistic legal assistance to help clients overcome poverty and violence, maintain their independence, and achieve self-sufficiency through a variety of programs and services. Our senior law program is just one of the many programs we offer to our clients. The senior law program provides compassionate representation to clients who are 60 or older. And one of our most requested areas of service include estate planning or financial planning for older adults. And this is the reason why we're gathered today. We're looking forward to discussing this topic with you. First, what is an estate plan? An estate plan is a collection of documents that protect your assets and establishes how you would like your affairs to be handled in the event of incapacity or death. Your estate is your property. It's your real estate, your vehicles, your household items, your financial accounts, etc. Now, there are 4 main elements of an estate plan. This includes a will, a trust, a power of attorney document, and an advanced healthcare directive. These documents are often used in tandem to help guide and minimize the probate process for our loved ones. Probate is a court-supervised process of transferring legal title from a person who has died, the decedent, to that person's heirs or beneficiaries. Probate is necessary to protect the rights of the probate estate of a decedent's heirs, devisees, and creditors. Now, why is it important to create an estate plan? There are a lot of reasons why we should create an estate plan, but the easiest way to explain the importance of an estate plan is to talk about what goes wrong when one isn't in place. Let's look at a couple of examples. Donna is retired. She lives on a fixed income. She's worked 30 years to pay off her home. She raised 3 children and cared for 6 grandkids in her home. It is her most important possession, and she wants it to stay in her family. She tells her son that she would like him to have the house when she passes away, but she does not leave a will or a deed or an estate plan to that effect. When she passes away, her property is distributed according to the laws of Missouri, and each of her heirs, whether it's her 3 children or her 3 children and her 6 grandchildren, or some combination of the 9, each of those heirs will receive a share of the house. The title of the home is now divided between 3, 6, or 9 people, some of which may be minors. Some family members may not want to give the house to David. And if the family cannot agree on what will happen to the property, a fight may ensue and the matter may proceed to a costly and time-intensive court battle. Let's continue talking about Donna. A neighbor tells Donna that she should add her son to the deed of her home now so that the property will automatically transfer to him when she passes away. Donna thinks this is good advice. So Donna signs a quitclaim deed, adding her son to the title. Later down the line, Donna tries to get a loan to make repairs to the property, but her loan is denied. She learns that there are new liens against the property. It turns out her son was sued for child support, and a court judgment was entered against him. This judgment attached to the home as a judgment lien. Now, although it is common practice and often common knowledge in our communities, adding others to a property deed via a quitclaim deed comes with significant risk, like we see in this case. We call this process creating a joint tenancy or a current ownership, shared ownership in a property or asset. When you add someone to a deed to your home, you give them a current ownership interest in the house. In addition to a host of problems, doing this means that that person's creditors can attach those debts to the property. And in most cases, this is not what the individual intended. It's important to know that under Missouri law, many types of court judgments can attach to property that's owned by a debtor. And those judgments may stick with the property until they are paid off or otherwise resolved. Please know that once a non-mortgage lien is placed on your home, the holder of that lien can make it very difficult for you to sell the house, to refinance the house, or to get a home repair loan, as we see in Donna's example. Let's talk about Regina. Regina is very sick, and she decides that now is the time to have a loved one help her manage some of her finances. Regina would like her granddaughter to help her pay her bills. So she adds her granddaughter to her account as a joint account holder. The granddaughter is sued for a past due credit card, and the creditor garnishes money from Regina's account. Alternatively, the granddaughter makes multiple withdrawals from Regina's account, the cumulative total exceeding $7,500. Again, these situations may have been avoided with proper estate planning, whether through a power of attorney document or establishing a trusted contact with the financial institution. Again, I will reiterate that although it may be a common practice to add other people to your accounts as joint account holders, this comes with significant risk. This creates a current or a present ownership interest in that account. And often that is not what individuals really want to do. Doing this means that that individual's creditors may attach debts or garnishments to that account. It may also result in a loss of control or financial abuse of the original account holder. People should proceed with extreme caution. So let's keep talking about Regina. Regina's condition worsens. She's now unresponsive. Her medical providers contact her next of kin regarding life-prolonging measures, but Regina never discussed her wishes with her loved ones. Now her family members disagree about whether Regina would want life-prolonging procedures. Does she want to be put on a ventilator? Does she want feeding tubes? Would she be okay with a blood transfusion? And because of this uncertainty, conflict ensues. We look further down the line and Regina passes away. Now her family cannot agree about what to do with her body. Did Regina want to be an organ donor? Did she want to be buried? And if so, where? Or would she have preferred to be cremated? The family is left with no guidance and no instructions. With no medical power of attorney, with no healthcare directive, with no right of sepulture designation, there are no instructions left for her loved ones or her medical providers to follow. Let's look at Reginald. Reginald expects that he will have to move into a nursing home in the very near future. He decides that now is the time to give his kids and his loved ones an early inheritance. He gives his house to his daughter and her partner. He gives his car to his grandson, who's in desperate need. He gives $20,000 to his son for a new business endeavor. Reginald is very surprised when his application for long-term care services is denied. Unbeknownst to him, he is being penalized for violating the look-back period. Many older adults find themselves in situations where they must apply for Medicaid long-term care in order to receive needed healthcare benefits and services, whether they receive those services in their home, at an assisted living residence, or in a nursing home. To be eligible for Medicaid long-term care services, one must meet very strict income and asset limits. To prevent people from simply giving away their possessions to family and friends and then relying on the Medicaid system to pay for these services, the Medicaid agency will review all applicants' financial histories dating back up to 5 years. All asset transfers during the look-back period are reviewed. If money or assets exchange hands for less than fair market value during this 5-year period, it is likely that the individual will incur a penalty and be deemed ineligible for healthcare services. And to top it all off, Reginald receives a very large tax bill for exceeding the annual gift exclusions under our IRS rules. So it's important to know that many types of gifts may be considered taxable under our IRS rules. This means Reginald has to file a gift tax return in the year that he makes a transfer when the value of that transfer exceeds the annual exclusion level for that child. And this level changes each year. For 2022, that level is $16,000. And for 2023, that level is $17,000. Because Reginald transferred the ownership of his $200,000 house to his daughter and her partner, he has exceeded that exclusion rate for the tax year. And because he gave $2,000 to his son for the new business endeavor, he has exceeded the exclusion rate for that child for this tax year as well. It is very important that we consult with qualified professionals before considering this as an option. Additional details about the gift tax liability can be found online at irs.gov. So why Is estate planning important? When we consider the examples presented to us through Donna, Regina, and Reginald's cases, what we see is that when proper estate planning has not been done, chaos can erupt, confusion can erupt, it creates uncertainty, and then there can be unnecessary penalties and financial loss. Creating an estate plan can help bring order during periods of incapacity or loss. Now, what steps can I take to prepare for a time when I may be unable to make decisions for myself? The great news is that there are a lot of advanced care planning tools to help you prepare for diminished capacity. Oftentimes, we don't like to think about our inability to take care of our personal selves, to manage our needs, or to manage our finances. But with a little thought and planning, we can ensure that we are able to age our way. Aging our way, engaging in advanced care planning helps to make sure that your values, your priorities, and your preferences are known and respected. It will avoid unwanted medical interventions. It can lift the burden of uncertainty from our loved ones, can help our medical team know whose judgment we trust the most, and it can also help prevent family conflict. The first type of advanced care planning tool is a power of attorney. A power of attorney is a document by which you appoint a person to act on your behalf. It is essentially a contract between you and that individual that gives them authority to take certain actions for you. Now, a power of attorney can cover a variety of topics. You can have a general power of attorney that covers the ability to manage your finances, to pay your bills, to dispose of your real estate, to give gifts to other people, and other actions. Or it can be limited to very specific steps. The good thing about a power of attorney document is that you decide what authority you want to grant to an individual. And that agent can only act within the authority that you spell out in that document. Now, your agent is someone who is authorized to act for you. It can be any adult over the age of 18, and it is often a close relative, a lawyer, or another trusted individual. In many instances, completing a power of attorney document and appointing an agent is a far better option than making a loved one the joint owner of your assets or the joint owner of a bank account. The other good thing about a POA or a power of attorney document is that you can revoke it and cancel it at any time. You can also determine when that power of attorney document goes into effect. It can become an immediate transfer of authority if you want it to go into effect right away, or it can be a document that springs into action when a specific circumstance is met, such as when a medical provider determines that you are unable to manage your personal affairs. You can determine how many medical providers have to say that you're unable to manage your personal affairs before it goes into effect. You can decide that one doctor is enough, or maybe two. What's important to know is that you determine and you specify your wishes in the power of attorney document. You have full control over what it allows, when it goes into effect, and how long it remains in effect. It's important that a power of attorney document is carefully worded to make sure that your wishes are effectuated and that it is appropriate to your unique circumstances. You should seek the assistance of a Missouri lawyer who practices in this area if you are considering this option. Other advanced care planning tools include using trusted emergency contacts with your financial institution. Adding a trusted or an emergency contact on your financial account does not give this contact or this individual the ability to manage your money or to make withdrawals from the account. It allows the financial institution to communicate with a third party under limited circumstances. For example, if your financial institution notices an irregularity in the spending habits on your account, adding a trusted contact to that account will allow the financial institution to reach out to that third party to express concerns when they're unable to reach you. Additional information about this option is available online in the hyperlink provided in your resource materials. The next type of advanced care planning tool is called a Social Security Advanced Designation. This is specifically for individuals who receive benefits through the Social Security Administration. An advanced designation allows you to designate up to 3 individuals who could serve as a representative payee if the need ever arises. It's important to know that it does not appoint them as your immediate representative payee or take away your ability to manage your funds yourself. You can submit your advanced designation request to the Social Security office online by visiting ssa.gov or by contacting the office via telephone at 1-800-772-1212 or by visiting your local Social Security office. In order to complete this process, you will need to give the Social Security Administration the names, telephone numbers, and contact information of your designees. And the good news is that it's not permanent. You'll receive a notice each year listing the names of the individuals you've chosen to advance designate, along with reminders regarding how you can update and change this information at any time. The next type of advanced care planning tools are specific to healthcare decision-making. This includes a power of attorney for healthcare purposes. Now, a power of attorney for healthcare purposes is essentially the same as a general power of attorney. The only difference is that this one is specifically for medical decision-making. A healthcare power of attorney is a document that appoints someone 18 years or older to make healthcare decisions on your behalf. This agent may only act within the authority spelled out in the power of attorney document. And oftentimes the authority that's spelled out is very specific to healthcare or medical decisions. Just like a general power of attorney document, a power of attorney for healthcare can be revoked at any time, and it is effective at the appointed time. So you determine when it goes into effect. Similarly, a healthcare directive and or a living will is a set of instructions that outlines your healthcare wishes. A living will is a brief declaration or a statement that a person may make indicating their desire for or against certain types of medical treatment. Now, why should you give an advance directive? You accomplish at least 2 things by giving an advance directive. You can direct all possible treatment, no possible treatment, or only some treatment. First, you ensure that the treatment you receive is the treatment you desire, no more, no less. Secondly, you take the burden off of your family and loved ones to make those decisions for you at a time when they are likely to be emotionally upset because of your change in circumstances. Finally, you can help avoid any litigation that may come or that may be required to determine what treatment you really want or intend. Most advanced directives will address a number of concerns. It should identify who should be making treatment decisions. It identifies who can receive confidential medical information under HIPAA. It will determine or should specify who has the right to make funeral arrangements for the individual, who may make anatomical gifts or organ donations, if any, and whether you would want artificial nutrition or hydration to be provided or withheld. The Missouri State Bar Association has prepared a durable power of attorney for healthcare and healthcare directive and a HIPAA privacy authorization form for free for everyone across the state of Missouri. These forms are available online at MissouriLawyersHelp.org. Additional types of advanced care planning tools specific to healthcare, medical, or sepulture issues include a do not resuscitate order or a DNR. A DNR is a medical order that's signed by a patient and their doctor that orders that no CPR be performed on the patient in the event of cardiac or respiratory arrest. CPR includes cardiac compressions, intubation, artificial ventilation, defibrillation, or other related medical procedures. Another advanced care planning option is the organ donor registry. And so individuals can, if they wish, register with Donate Life Missouri to record their election regarding their organs online at donatelifemissouri.org. Additionally, a right of sepulture designation is available for anyone who wants to designate someone to exercise the right of sepulture over their body, meaning this individual would determine whether or not you are buried or cremated and what should happen to your body upon your passing. And lastly, a HIPAA authorization authorizes medical professionals to share medical information with trusted third parties. It's important to know that although we've listed a number of documents and advanced care planning tools that one can consider, one does not have to have all of these documents. The proper estate plan for you will include a combination of different types of documents based on your wishes and desires. For example, I may want to appoint one loved one to make medical decisions on my behalf. And I may decide that it's really in my family's best interest to have another person be responsible for my right of sepulture, determining what happens to my body and handling my funeral arrangements. And while I may have both of those documents in place, it may be important to me to make sure that my election to be an organ donor is well known to everyone in the community. And so I may, in addition to that, register with Donate Life Missouri. I may also decide that I only want one person to have access to my medical records. And because of that, my healthcare power of attorney may be sufficient for that purpose. But what if I decide that I want one person to make my medical decisions for me, but I also want to make sure that all of my siblings have the right to access information about my medical care? So I may give a healthcare power of attorney to one person, but provide a HIPAA authorization to my siblings. And so the right combination of documents will be specific to each individual based on their specific wishes and their circumstances. So while you don't have to have all of these documents to have a thorough estate plan, any combination of these documents may suffice based on the circumstances. Now, when determining who to act as your agent or who would be in the best position to serve on your behalf when you're in a position of incapacity, we've offered here 4 tips for selecting an agent or a trusted contact. The first tip is to select someone who will respect you and your wishes. This should be someone who will be there for you when you need them, that you can trust to follow your wishes and to do what's in your best interest. And this is someone that you can trust to know your personal information, whether it's your financial information or your medical information or both. The second tip is to select an agent who will support you in the decision-making process, even as your capacity changes, and will only use substituted decision-making when absolutely necessary. It is important that you select an agent who will keep you involved in the process so that you are able to maintain some sense of autonomy and involvement in your life as much as possible. The next tip for selecting an agent is to choose someone who has strong communication skills. This should be someone who can speak to you about your wishes and who can speak on your behalf to others about your wishes. This should be someone who is not afraid to ask doctors questions or to advocate on your behalf. In addition, this should be someone who will be able to keep those you loved informed. It's a terrible feeling to have someone acting on your behalf that refuses to communicate with your other loved ones about what is happening in your life. So choosing an agent who has excellent communication skills is very important. Lastly, your agent has a duty and a legal obligation to manage your affairs and to do what is in your best interest. So selecting an agent who will keep detailed records and ensure that you receive the best care possible is really important for preserving and respecting your wishes. So what steps can I take to transfer my personal property and assets to my loved ones? Again, there are several estate planning tools that are available to help you transfer your property in ways that reflect your values and your wishes, that protect your assets, that will save you and your loved ones money and limit financial penalties, that will help minimize conflict and provide ultimate peace of mind. In order to understand which estate planning tool may be best in a particular situation, it's helpful to understand the probate process. So earlier in our discussion, I showed a chart that had 5 things on it and explained that 4 common elements of an estate plan is a will, a trust, a power of attorney document, and an advanced healthcare directive. And that these documents were often designed to help minimize the costs and time required through the probate process. So let's start with probate. Probate is a court-supervised process of transferring legal title from a person who has died, the decedent, to that person's heirs or beneficiaries. Probate is necessary to protect the estate of the decedent, to protect the heirs, devisees, and the creditors. Now, the probate process is a court process. It includes a number of things. It includes filing a petition in the probate court in the county where the person passed away. It includes deciding first if there are any assets to add to that probate estate, and then locating each of those assets and managing them, valuing those assets and providing that information to the court, paying taxes on behalf of the estate based on the value of those assets, setting up an estate checking account and potentially an EIN number, interpreting the will if there is a will, and if there is no will, then distributing those assets according to local law, It also includes communicating and working with the heirs and the beneficiaries, notifying creditors, following legal deadlines, and so forth and so on. It can be a very costly and time-intensive process. Oftentimes, people believe that if I have a will, that eliminates the need to go through a probate process, which actually isn't true in the state of Missouri. In the state of Missouri, a will must be probated within 1 year or it will expire. An effective estate plan will help minimize this process to the extent possible, understanding that the larger the probate estate is, the more the cost and fees will be associated with administering it. So an effective estate plan will start with every option that will help to minimize and avoid the probate process, to go around that process to the extent possible. So the first thing we do often is encourage people to create an inventory of their assets and their debts, to make a list of everything that they own that is a part of their estate, right? That needs to be accounted for through their estate plan. And then we encourage people to sort that list by property that can be transferred outside of the estate process. Outside of the probate estate process. This is so that people can dispose of as many assets as possible through non-probate transfers, again, to save those loved ones, to save their loved ones time, money, and hassle through the probate courts. The first type of non-probate transfer is called a payable on death account. And these can be a great option if you want to set up an easy and seamless way for assets in a bank account to transfer to a beneficiary after you pass away. A payable on death account is a good way to bypass the often complex and stressful probate court process. This is because when the original account owner passes away, it triggers an automatic transfer of that value to the named beneficiary. The next type of non-probate transfer is called a transfer on death. It is very similar to a payable on death account, but a transfer on death transfer can be for accounts or other types of assets. Through a transfer on death designation is a formal designation that identifies how title or ownership of a specific asset should be transferred after you pass away. So you can do a transfer on death designation for a vehicle that you may own, for a motorcycle, for a boat, or other type of automobile. You can do a transfer on death designation for most stocks, bonds, mutual funds, and deeds of that nature. The next type of transfer on death instrument or non-probate transfer is called a deed of gift. A deed of gift allows an owner of property to name a beneficiary to receive their personal property. This includes my favorite watch, my favorite jewelry, my Mickey Mouse dishes, my bed set, my wedding dress, any personal property that I own, my record collection, any personal property. A deed of gift allows someone to transfer that property to another outside of the probate process, outside of a will, and outside of a trust. Now, a deed of gift can be a current transfer, meaning I would like to gift my phone to my son, and so I can do that as a current gift, or I can say, when I pass away, my son is to receive my phone upon my death. And that deed of gift exempts that phone from that probate process. The next type of non-probate transfer is called a beneficiary deed. A beneficiary deed allows a property owner to name someone to receive their real estate upon their death. The good thing about a beneficiary deed is that it is not a present transfer of ownership, similar to what we saw in our examples earlier. It will not result in a current ownership interest that creditors can use to attach to the property, but only upon your passing will that property transfer to that beneficiary. And such, it protects your ownership interest in the house, and it can be revoked or changed at any time without additional formalities. Now, the last type of non-probate transfer that we'll discuss today is a trust. And many of us have heard of a trust. A trust is an agreement that determines how a person's property is to be managed and distributed during his or her lifetime and also upon their death. Essentially, what happens is a settlor or the grantor creates the trust and they outline all the rules of the trust. They determine what property will be transferred into the trust and what will happen to that property once it's inside of the trust. Should this property be held and then transferred to someone else as is? Should this property be held and then liquidated and the funds slowly released to someone else, or the funds used to pay a certain bill or to pay for certain expenses over time? That is all determined in the language of the trust as written up by the trustor or the settlor. Now, the trustee is the person who holds title to the trust property and manages it according to the terms of the trust. Sometimes the person who creates the trust can serve as the trustee while they're living. At other times, they may appoint someone else or a corporation or a financial institution to serve on their behalf. The beneficiary of the trust is the person or entity that will receive the property in the trust or the income from the trust, the assets of the trust. And this can be whomever is established in the trust document or identified in the trust document as the beneficiary. It may be the person who created the trust during their lifetime, or it may be their children or a charity or someone else that that individual may name. There are essentially two basic types of trust. We have revocable trust and then we have irrevocable trust. A revocable trust is one that can be changed or amended or canceled at any time. In a revocable trust, the person creating the trust reserves the right to amend it during their lifetime. An irrevocable trust is a trust that cannot be changed or amended. It has certain limitations in that regard. Oftentimes people ask, is a revocable living trust an adequate substitution for a will? And the answer to that is oftentimes not. Most estate planning attorneys will still create a will even though a trust is in place. And this is because once a trust is created, all of that person's assets have to be transferred into that trust. But let's say you create a trust in January and all the assets that you own in January are transferred into that trust. But then later on down the year, in June or July, you acquire new property, and that property has not yet been retitled or has not yet been transferred into the trust. In order to capture that property and to make sure that it remains a non-probate transfer, you have to have a will or something that's a catch-all to capture that property that may not have been adequately planned for at the time the trust was created. This is usually called a pour-over will. So again, you don't need to have every estate planning document that we're discussing today, but the right combination of each of these documents to address your needs will vary depending on your specific circumstances. So the last type of estate planning tool that we'll discuss today is a will. And most of us are familiar with that concept. A will is a legal paper that states who receives your property when you die. A will does not avoid the necessity of probate, and it must be probated to have legal effect. However, with proper estate planning, you can minimize what is included in your will and what has to go through that probate process. And in doing so, minimize the costs and effects and some of the financial consequences of that as well. So, who can make a will? Anyone who is at least 18 years of old can make a will and of sound mind. In Missouri, a will is considered valid when it's signed and the signature is witnessed by at least two people. And that will can be changed through an amendment that follows the same formalities as when the original will was signed, meaning any amendments have to be signed and witnessed and signatured by two people. The good thing is that you can cancel a will at any time by simply destroying the original will that you've made or issuing a letter of revocation. Sometimes it's helpful to have a will. Some common things that we see in wills might be waiving a bond that would be required through the probate process, or providing a clause that allows for the independent administration of your will, again, limiting that probate process. Through your will, you can nominate a guardian for minor children or disabled loved one that you care for. You can also make anatomical gifts or do other actions and take additional steps. So now we've talked about a lot of different estate planning tools. There's so many options to choose from. And the question is, are resources available to assist with the estate planning process? The simple answer is yes. There are a number of resources available for older adults across the state of Missouri. And a lot of these resources can be accessed through the Missouri Department of Health and Senior Services online at health.mo.gov/senior/AAA/legal. In the state of Missouri, our Missouri Associations of Area Agency on Aging is the leading voice for service, information, and advocacy to improve the lives of aging Missourians. There are 10 area agencies on aging across the state, covering every county in the state of Missouri. Legal assistance for Missourians 60 or older may be available through your local area agency on aging through partnerships and contracts with local attorneys under the Older Americans Act. Again, you can visit the Missouri Department of Health and Senior Services online for additional information, resources, and referrals to a AAA near you. You can also call the Missouri Senior Resource Line toll-free at 1-800-235-5503 to be connected with local assistance. In addition to the legal services program available through the Missouri Department for Health and Senior Services, there are legal aid providers available to assist with these issues as well, with funding support from the Legal Services Corporation and oftentimes in partnership with your local area agencies on aging. Legal aid providers may be available to assist you. From Atchison to McDonald County, from Mississippi to Clark County, and every county in between, there is a legal aid program that covers every county across the state of Missouri. You can also contact your local legal aid office for legal advice, assistance, or referrals, or to communicate with that office regarding community education presentations or outreach opportunities that might be available. Additional statewide resources include those available through the Missouri Legal Services Program and through the Missouri State Bar Association. General legal information on this topic and more is available online at Missouri Legal Services. Their website is lsmo.org. You can find a pre-recorded training on estate planning on the Legal Services of Eastern Missouri Facebook page as well. Additional legal referrals, pre-recorded trainings, legal guides, and sample forms can be found online through the Missouri Bar Association at mobar.org and MissouriLawyersHelp.org. Additionally, more resources are available online through the Consumer Financial Protection Bureau. There you can find information about selecting a financial caregiver, information and tips to help you plan for diminished capacity, and then also resources for individuals serving as an agent or a trustee in various capacities. And their website is consumerfinance.gov. Thank you again for your time and attention during this presentation. Do feel free to reach out to Legal Services of Eastern Missouri, and you can contact us by phone on our website, or you can visit any of our social media pages.